All right, good morning, everybody. Can everyone hear me okay? Okay, awesome. Yeah, Sherry, you have your hand raised?
My bad, sorry.
Oh, no, that's good. Um, Aaron, I think, are you sharing are you sharing your screen
Yeah,
with
let
the
me try it.
presentation?
Let me try it out.
Awesome.
How's that?
Looks good. I think just to make sure that we have enough time, we'll go ahead and get started. We go until 11:30. We were thinking that we would do the first section, take a short break, finish up, and then hopefully leave a lot of time for Q&A. I'm Wenley Dickinson. I'm with the Division of Water Resources in the Denver office. I've given this presentation before, so some of you might have seen me before. I did work in Division 1, but recently just switched over to working in Divisions 4, 5, and 6. And I have with me Aaron Mosley, also from the Denver office, if you want to introduce yourself, Aaron.
Yeah, my name is Aaron Mosley, and I've been with the division for about a year now, and I work in Division 1 outside the Denver Basin. And I'm a water resource engineer and a permit writer, so work on a lot of applications and take a lot of calls from realtors. And so I'm happy to get this presentation going for you guys and hopefully head off some of those questions and let you be better informed to serve your clients.
Awesome. Thanks, Aaron. I think yeah, that's a good point. We work a lot with realtors, title companies, consultants, attorneys, city and county employees, water suppliers. I think there's a variety of people online. We tried to tailor this content more towards realtors, but I do think that a lot of this information is relevant to a lot of other fields and professions. And that's also why we want to leave a lot of time for Q&A so that if we didn't answer your question, we can hopefully do that today. And I also wanted to say that this is being recorded. We will share this with anybody who missed it or just wanted a copy later. So just wanted to let you know about that as well. So go ahead and go to the overview of the different topics we'll cover today. We'll give a background on DWR as an agency, a brief history of water administration in Colorado. Then we'll go over the different types of groundwater as defined by statute, the difference between Water Court and the Groundwater Commission, and then we'll spend a decent amount of time going over well permitting basics, and then if you're selling or purchasing a property, what types of things to look for. So I'll go over the background on the Division of Water Resources, and I just also want to add a disclaimer that the information in this presentation is for informational purposes only. Our goal is to provide you with as much information as possible to help you navigate well permitting and water administration, but we can't give any advice or anything like that. And we also can't guarantee that well permits can be issued. Some of this information, all of the information in the presentation today should be up to date, but if you're watching this recording later, some of this information might change over time. So we also just want to let people know that as well. So the Division of Water Resources is one of several agencies within the Department of Natural Resources within the state. So other agencies are Avalanche Information, Forestry, Mining, Energy and Carbon, Parks and Wildlife, State Trust Lands, and Water Conservation. So our major responsibilities, I like to sum it up as three things, first being water administration, Also, public safety, we have well inspection and dam construction oversight programs, and also public information. So that's our Ask DWR portal where you can, maybe portal's not the right word, Ask DWR form where you can submit questions online. We have an info desk. We have presentations like this, guides online. So water administration, safety, and information is how I like to sum it up. Also on here, though, is well permitting. We issue well permits across the state. We also are involved in maintaining compliance with interstate compacts, flow measurement as well. So some quick stats. There's over 178,000 water rights in the state. There's over 105,000 structures, and structures can be like a head gate, a reservoir, a pond, or a well. And we have over 200, or sorry, that doesn't include wells. We have over 280,000 wells. And so sometimes we get questions that are like, you know, do you guys inspect every single well, or can you go out and look at every well? And we can't. There's over 280,000 wells. There's only about 250 DWR employees. I also want to point out that there are more water rights than there are structures, and that's because you can have multiple water rights on a single structure. There's also more wells than there are water rights, and that's because there are a lot of wells out there that don't have a water right and don't need a water right to operate. And we can talk about that more later. Most of water use in Colorado is for agricultural purposes. That's around 86%. The next biggest water use in the state is municipal and domestic uses. And then we have recreation, industrial, commercial, and then recharge. So that is water that's being used to recharge our groundwater, and augmentation, which we will also talk about later. You may have heard of Colorado being referred to as the headwater state, which means that we're at the headwaters, we're at the source of where a lot of water originates. And because of that, we have a lot of compacts. So we have those listed here on this slide. 19 states downstream of us rely on water from Colorado. So that's all of those states highlighted in yellow. So water administration and compact compliance is really crucial in Colorado because of the reliance on water from Colorado. And a lot of that is because we have the Rocky Mountains. And so essentially water that freezes and falls as snow and becomes snowpack in the mountains will melt and run off from there. So that's part of the hydrology of Colorado as well.
Thanks, Winley. Now we're going to talk about water administration in Colorado now that we have it, all this background information set up. So a little bit of basic vocabulary. We're going to hear more of these throughout the presentation, so it's good to get them out of the way. We have an adjudication, which is a confirmation of a water right provided by a judge from the water court. An appropriation is a specific action under the proper procedures of the law that creates a water right by placing water to beneficial use. An acre foot, this is going to be an important one. So an acre foot is a volumetric measurement. It's equivalent to nearly 326,000 gallons. Or it's basically just like it says, it's 1 foot of water over an acre of land. So you can imagine like about a football field size piece of land covered in 1 foot of standing water. So that volume of water is used in like volumetric limits when we talk about well permit limits. Curtailing is ordering a water right or diversion structure to cease and desist using waters. And we'll see why that's important in a second. Decrees or rulings come from the water court. And then a head gate is a type of structure that's used for controlling flow of water. And that's kind of how we use a head gate to do curtailing when someone meets their acre foot limit or things like that. So they all kind of go together. A little bit of history. The oldest water right we have in Colorado is from 1852. It's the San Luis People's Ditch. The beginning of water rights and water adjudication in Colorado started with surface water use, which was then rivers and streams. This water was used for mining purposes and domestic purposes. This water use predated the creation of Colorado as a state, and so we didn't have a state constitution for water rights to be kind of explicitly spelled out in. And there was an increasing demand for this finite resource, and that led to competition. So like I said, the oldest water right we have in Colorado is 1852. And then around 1859, the 1860s, we saw the beginning of the gold rush in Colorado. Again, this is before we were a state. And so we had a increasing demand for water in the state. In 1861, Colorado became a territory, and then in 1866, the Mining Act allowed territories to establish their own water laws. And then in 1872, the Territorial Supreme Court allowed building water diversion, conveyance structures in public and private land as a necessity of living in an arid climate. So since surface water is limited, we have to kind of move it around beyond where it naturally flows. So our water rights competition started with mining, and then irrigation demands were added to grow crops to feed the miners. And since we have a arid climate here in Colorado, this led to competition and conflicts. 2 decades later, in the 1870s, Colorado became a state, and the prior appropriation system was put into our state constitution, and the prior appropriation system is what we have now. We're going to talk about that. So we have, like I said, a prior appropriation system, which is in place in a lot of the Western United States where water is a more limited resource. And that's contrasted with riparian water rights systems, where riparian means when you have water like on your property, if you have a creek running through your property or a lake on your property or adjacent to your property, you basically have a water right to that water just because it's near you. But like I was talking about in Colorado, since we have limited surface water and we use irrigation ditches or conveyance structures to transport it around, just being near the water doesn't grant you a right to use it. We have the prior appropriation system in which older water rights are protected from injury from more junior water rights. So a couple of things that define our Colorado water doctrine is that water is a public resource which can be transported away from natural waterways. So in prior appropriation, as opposed to riparian, just being near the waterway doesn't allow you to have a right to that water. And that's because we recognize that we can transport water around the state. And so that riparian system doesn't work for us. A water right grants an individual or a group the right to put water to beneficial use. And so that's a key component, is that you can't just have the water to have it. It has to be a beneficial use, like a domestic use and irrigation use or recreational use. And there's restrictions on those water rights, including quantity restrictions. So it can be an acre foot restriction, point of diversion. So we need to know exactly where the water is coming from out of the system. There's restrictions on allowed uses and some more. And like I was saying, water rights are granted in priority, meaning older water rights are senior to more junior water rights. That's what prior appropriation kind of boils down to. So in practice, what does that look like? So here we have a stream with 100 CFS, which CFS stands for cubic feet per second. It's another volumetric flow rate. So you can imagine 100 basketballs going down a river at any one segment at any time. That's how I would visualize 100 CFS. So in this example, you have a senior water right towards the top of the screen that was decreed in 1860 for 70 CFS. And then you have a more junior water right, 1880, so 20 years later, for 50 CFS. So how would this work in practice? So we have the stream coming down. We only have 100 CFS in the stream. The senior water right, which is a water right for 70 CFS, and then we have the junior water right for 50 CFS. And so if you can imagine doing some quick math, there's not enough water in the stream for everyone to have their water right fulfilled. And so since we have a senior water right and a junior water right, the junior water right is required to curtail their water right to prevent injury to the senior water right. Hopefully that makes sense to everyone. There's not enough water in the stream, so basically prior appropriation means the senior water right gets to have their water right fulfilled, and then we go down to the next most senior water right, and they get to have their water filled, and so on and so forth. And so you can imagine, like when Lou's talking about, there's hundreds of thousands of water rights now, and so that list gets pretty long and competitive for this limited amount of stream flow. So since there's so much competition for this limited service water, we developed this augmentation plant system. So if you can imagine someone with a 1950 water right or a 2000 water right trying to get water when there's these water rights that are hundreds of years old, which have priority over that it would be very hard to fulfill like a more recent water right. So we came up with these augmentation plans. These plans are approved by the water court, and they provide replacement water into the system, which is specific in the time of the replacement, the location of the replacement, the amount of replacement. And this is required in areas that are deficient or over appropriated. So in this example, you can see in the bottom right, perhaps a ski area that's pumping a well at 5 CFS. We already know there's not enough water in the system for this 1950 water right to take that water without injuring one of the older water rights. And so for this 1950 water right to be fulfilled, they would have to find a source of replacement water. So if they're pumping out 5 CFS to blow snow for the ski resort, they would have to find 5 CFS from either getting it from some older water right or another source of water and replace it into the stream in a similar time, location, and amount to prevent any injury to the more senior water rights. So yeah, just to detail these augmentation plans, they're approved by the water court. This is like an official plan approved by the court, and it describes how the replacement water will offset depletions from junior water use to prevent injury to senior water users. Like I said, the replacement water is provided in like time, location, and amount so that the stream system remains unaffected by the junior water right pumping. These are required in areas that are water deficient, which is most of the state, and we technically call this over appropriated, where more water has been appropriated out than there exists in the system. And there's several potential replacement sources that the water can come from. So a reservoir can be decreed to be used for augmentation and replacement. Senior water rights can change into augmentation uses, usually by drying up typically irrigated fields. Then the water becomes available for augmentation. You can have trans-mountain water, which brings water into the system, into a basin that wasn't there before, or you can have recharge accretions. So water can go back into the aquifer, and we'll see how those are connected in a second. So we've been talking about this prior appropriation system and how senior water rights are protected from injury. This applies to most of the water in the state, and all surface water and groundwater here are presumed to be tributary. Tributary means there's a connection between the rivers, between surface water and groundwater, and this water will be administered under the priority system. And what is not administered under the priority system is non-tributary groundwater, which is the Denver Basin aquifers, or exempt wells, which have a statutory exemption. And this is what Winley was kind of highlighting on earlier, that we have more wells than we have water rights. And that's because we have this type of exempt wells, which don't need a water right. They're exempted. And then contrasting with exempt wells is non-exempt wells, which we'll talk about. So non-exempt wells are required to be administered in the priority system, similar to surface water rights. And why must these wells be augmented, and why can't we just stop pumping? So if you imagine that example we had with the stream, and someone was diverting water from the surface water, it's pretty clear that taking water out of a river when there's a senior water right downstream will affect that senior water right. But if you're pumping from a well that's maybe a couple miles from the stream, it's not as clear. But we'll see later in this presentation, I'll highlight it now, that like if you're pumping from a well that's connected to an aquifer and the aquifer is recharged by the stream, when you pump that well, it takes the local groundwater, which pulls on the groundwater next to it and pulls on the groundwater next to it, so on and so forth, until you get to the stream. And so that water is drawn into the aquifer from pumping the well miles away. And that delay and that recharge takes time. And so you can't, if you just stop pumping your well a couple miles away, it could take days, months, or even years for that recharge and that lagged depletion to actually be felt by the stream. And so you can't just turn off your well when there's a senior water right being injured, because that lag depletion takes time. And since we can't just turn off the well, we need to make sure that the senior water rights are protected. When you pump from a well that is non-exempt, we would require an augmentation plan. So basically replacing that water immediately or in like amount, time, and location, so that the senior water rights are protected. So we talked about where these augmentation plans would be required for non-exempt wells. And their augmentation plans are required in the over-appropriated areas where there's not enough water. You can see this red area. It's the vast majority of the state, including all the Front Range, the Pueblo area. So divisions 1, 2, and 3 are entirely over appropriated, and you can see that from kind of the top right of the state, moving clockwise, 1, 2, and 3. And then divisions 4 through 7 have some areas where water rights calls do not occur yet. And then we have some newly over appropriated areas as well. So the state is moving towards being completely over appropriated, although we aren't there yet.
Great, thanks, Aaron. So next I'm going to cover the different types of groundwater as defined by statute or by law. And there's 3 main types if we go to the next slide. So there's tributary groundwater, which Aaron already talked about, but just a reminder, this is water that's connected with surface water. Tributary water is typically water in springs, ponds, rivers, lakes, reservoirs. That all surface water is basically tributary. Most groundwater is also tributary because, like Aaron said, there is that hydraulic connection between groundwater and surface water. So pumping your well even miles from the nearest stream could impact that stream, and that water would have to be administered in the priority system in that first come, first serve kind of basis, and would likely need an augmentation plan in a lot of cases if you're in those over appropriated or critical areas that we saw on the previous slide. Then there's non-tributary groundwater, and that's water that has very little connection to surface water. So if you were to drill a well in a non-tributary aquifer and pump that well, there would be very, very little to no effect on the stream system. And so that groundwater is administered differently from groundwater in the rest of the state. So probably the best example of non-tributary groundwater is water in the Denver Basin aquifers, which we'll talk about a little bit more. And then there's also designated groundwater. That's groundwater that is in basins on the eastern plains. And that groundwater, while I guess from a hydrology sense is the same as other groundwater, it's just in an area that has its own rules. So we'll look at a cross section here. At the top, there's a arrow pointing to tributary surface water. So that's a stream or river there. That's obviously tributary. Then on the right, there's tributary groundwater. So that is water that might be somewhat shallow, but not always. Pumping water from that aquifer there is going to impact surface water. And then in the bottom left, we have non-tributary groundwater. That's groundwater that if you pump it, there will be very little effect on surface water. And again, the best example of that is Denver Basin groundwater that is not administered in the priority system. So on the next slide here, we'll see a map of the Denver Basin aquifers and their extent. So on the left here is showing the different Denver Basin aquifers. There's multiple Denver Basin aquifers and they are layered on top of each other, kind of like a layered cake. So if you are in Castle Rock and you drill a fairly shallow well, you might be in the Dawson Aquifer, which is sitting on top. But if you drill deeper, you might hit the Denver, Arapahoe, Laramie, Fox Hills aquifers. These are different aquifers that are separated by a confining layer. So water doesn't really travel between these different aquifers. And that's why they're non-tributary, because of that confining layer. Water does not travel between those aquifers and surface water. So on the right is the extent of the Denver Basin aquifers. So it extends basically from Colorado Springs up to Greeley, and then kind of along the foothills out east almost to Lyman is where the Denver Basin is. So if you have a well in one of these areas, you might have a well that's in a Denver Basin aquifer and would not be administered in the priority system. So I just want you guys to remember that a lot of the concepts that we talk about today are for tributary groundwater. But if you have a non-tributary Denver Basin well, the permitting options or what you can do might look a little different. So I also talked about designated groundwater. Designated groundwater is groundwater that's in these designated basins. These are, I kind of think of them as administrative boundaries. If you're in one of these shaded areas on the Eastern Plains, you're in a designated basin and you're subject to the designated basin rules, and they don't operate under the priority system either. They have a slightly different system. So that's just another piece to keep track of. If you're out in one of these basins, like I think I see Town of Kiowa online with us here, you would be in a designated basin and be subject to the designated basin rules as opposed to the rest of the state that is not subject to the designated basin rules. And these areas out on the Eastern Plains have very little surface water. They rely primarily on groundwater. And that's why these basins are administered differently. So this is a quick review basically of the factors that go into determining what type of groundwater you have and therefore how that groundwater is going to be administered. The first thing you want to look at is location. Are you inside or outside of the Denver Basin, or are you inside or outside the designated basins? You could be outside of either, or you could be inside just Denver Basin, inside just designated basins, or inside of both. So that's just an extra layer of complexity if you are in one of those areas. And then the other consideration is just how connected to surface water that groundwater is. If there's a connection, then it's tributary. If there's little to no connection, essentially, then it's non-tributary and not administered in the priority system. And then Denver Basin has a fun third type called not non-tributary. We won't get into that too much, but just know that if you are in a Denver Basin aquifer and that aquifer is not non-tributary, so there is some connection to surface water, if you have a non-exempt or large capacity well, you will need a replacement plan or an augmentation plan.
Okay, so now that we have this these systems set up, we're going to talk about water court and the groundwater commission. And these two systems, the court and the commission, kind of administer the basins and the distinctions between these water systems. So the water court has jurisdiction in water rights matters. Us at DWR, we do not approve or change water rights. That's up to the court to do. Colorado's court, the water court is Colorado's court system just for surface water and groundwater matters. So they cover all rivers, ditches, springs, reservoirs, groundwater. And the water court does groundwater that's outside of the Denver Basin, those designated basins that Winley was talking about. There's 7 water courts in Colorado. Each court has its own judge, referee, and a clerk. And the court approves decrees for water rights, change of water rights, plans for augmentation, storage rights, and exchange. So, like I mentioned, there's 7 water courts. There's one for each division. And the water courts are required to be in the division which they serve. So for Division 1, we have a court in Greeley, Division 2, Pueblo, Alamosa, Montrose, Glenwood Springs, Steamboat Springs, and Durango. And so if you have a question about a water right in your specific, in those divisions, that the water court in that division would be a good place to ask that question if you're not going to send it to us. And these divisions are basically the river basins. So Division 1 is the South Platte, Division 2, the Arkansas, Division 3 is the Rio Grande, I believe. Division 5, Colorado, Division 6 is the Yampa, and then the tributaries that are contained within those as well. So apart from the water court, which the water court handles the water outside of designated basins, there's the groundwater commission, which administer groundwater within the designated basins. So like Winley said, the designated basins are on the eastern plains of Colorado, and they have very little surface water. So the majority of their water users rely primarily or solely on groundwater. And so since groundwater is kind of the only supply of water, it made sense to have these special commissions to administer those. The Groundwater Commission established 8 designated basins and 13 management districts within those. The Groundwater Commission handles water rights and changes of water rights in their jurisdictions. And they also have replacement plans or administer replacements, which are similar to augmentation plans, but finding replacement water when there's no surface water and everyone's kind of using the same groundwater aquifers, those finding water for those replacement plans can be quite difficult. So again, showing kind of where the Groundwater Commission has jurisdiction entirely on the Eastern Plains. The commission, as opposed to water court, the water court has jurisdiction in these areas, and well permitting options differ from outside of these designated basins. So there's specific rules for these designated basins, and those can kind of break down into large capacity and small capacity well permits. Just 1 second, I lost my. So in summary, the water court is the adjudicatory body for water rights outside of the designated basins. So the entire western half of the state and all of the eastern half of the state that's outside of those designated basin areas we showed on the map. The Groundwater Commission is a regulatory body for water rights inside the designated basins. And then thirdly, we have us at DWR, or can be referred to as the State Engineer's Office. So we administer water rights as they're decreed by the court and the Groundwater Commission. And the DWR includes the state engineer, division engineers, and staff, including engineers like myself and Winley, and then techs, water commissioners, and administrative staff as well. So moving on to some of the stuff that we do at DWR as well, permitting. I feel like this is probably of interest to this group. We do field a lot of questions about well permitting and is my property eligible for a well permit? And so this is kind of the topic or the section for that. And so when we get into those specifics, I'll call it out, but all these things are going to be kind of relevant.
Could I jump in? Could I jump in real quick and just say, if you have a question, we can answer questions at the end of the section if you want to unmute yourself, or if you want to drop your question in the chat, I can try to get to that while Aaron's talking, just letting everyone know.
Mm-hmm. Yeah, thanks. Yeah, this is definitely meant to be, educational. So if you guys have questions, feel free. I think this is a great time for it. So some well permit basics. They're issued to construct new wells or use existing wells, and they're issued and enforced by DWR. I think this application process is pretty important to highlight. We have an e-forms dashboard, and here is the link to it. I have it bookmarked, but I typically instruct people to find it by just Googling DWR e-forms. And here you can find the residential application permit, our change of ownership name form. So if you have a client that's buying a property that has a well on it, you would want to get that well transferred into your name, into your client's name after the sale goes through, so that they can have it registered to them. That change of ownership form is there. Location amendment form is there. Basically all of our forms are there in the most recent versions. And then those get emailed to our DWR permits online. Some information on the fees. Incomplete applications typically take 4 to 6 weeks. We do see a lot of incomplete applications, and that just adds to the processing time when we have to go back and forth with the client, or if they haven't if they haven't provided everything. So I do stress that like complete applications are preferred, and it helps everyone just kind of get the permits moving along. So where do well permits fit into this system of water rights augmentation plans like we've been talking about? So just to draw some distinctions between them, water right is approved by the court. It grants a priority date. Water rights are usually conveyed by deed. So if you're buying a property with a water right, you want to make sure that if your understanding is that the sale will include the water right, that's spelled out in the deed. A seller could choose to sell a deed to a land, but not a deed to a water right. So it's something you want to make sure that is spelled out. They're not connected to each other intrinsically. And a water right will require a well permit to use groundwater. So a water right in and of itself isn't everything. So then that's where well permits come in. They're issued by us at DWR. It's a permit to construct or use a well. A well permit does not grant or convey a water right. They're different things. And it also necessarily doesn't require a water right, because we talked about a type of exempt well permit, which do not require water rights. And then you have augmentation plans, which we discussed earlier. These are approved by the water court and allows water to be diverted out of priority by providing replacement water. We've been kind of workshopping this analogy that comparing these to cars, where a water right is like a title to a car, where it's like, I have a car. But that's not all you need to be able to drive a car. You would need a driver's license, which we would consider like the well permit, which says, okay, you have a car, you can drive it. And then augmentation plans fit in kind of awkwardly, but we were thinking about it this morning of like an augmentation plan is like gas, that some cars need gas, some cars, I would contrast like an internal combustion engine car versus an electric vehicle, which you don't need to go to the gas station all the time. You just have energy at your house already that allows you to drive it. But some cars need gas, and some wells need augmentation plans where the water that you're using is replaced, and that allows you to continue using it. So again, augmentation plans are approved by the water court. They're not approved by DWR, and allows water to be diverted out of priority by replacing that water. So I brought up the distinction between exempt wells and non-exempt wells. Typically, when you see exempt wells in our system, they don't have a suffix. They don't have an A or a WCB or an F suffix. These exempt wells are limited to domestic and limited commercial uses. These are not administered in the water rights system, as we've been talking about. And the only way to get one is for your property to qualify for an exempt permit. We'll talk about that in a second. And that's contrasted with the non-exempt wells we've kind of been talking about. These non-exempt wells have a suffix, an F or an R, maybe FP. They can have some more uses, including municipal, crop irrigation, industrial, or domestic use in large subdivisions. This is administered in the water rights system, and that kind of allows it to have more uses. So since these are administered in the water rights system, the water that's being pulled out of these non-exempt wells is being replaced by an augmentation plan. So, and since it's being replaced, you can have some more uses like irrigation, industrial, since we're guaranteeing that these uses won't impact senior water rights. Like I said, they need an augmentation plan, and the pumping rate and volumetric limits would also be installed, because without a volumetric limit, you don't know how much water needs to be replaced. These can require meters, so totalizing flow meters, and they can also have 600-foot spacing requirements. So we're ensuring that wells aren't going in too close to each other and kind of competing with each other. Okay, this is kind of where we're going to get into the nitty gritty of can my property get a well? That question. I feel like we fielded this question a lot through both the Ask DWR portal and the info desk we have, both Winley and I, and pretty much everyone at DWR and Division One or at the Denver office takes turns on the info line. So we have all fielded this question at some points. And so this is kind of, if you ever had a question of can my property or is this home eligible for a well permit, this is the an exempt well permit. This is going to be that process. And so it starts with is the property in a water service area? So the water service providers have basically first right of refusal for homes or properties in their water service area. So a water service provider can object or not object to a well being put in their service area. Some service areas they want to provide water to everyone that they're able to, and some water service providers have like tap moratoriums where no more taps are being added. They're kind of at capacity. So the first question is your property in a water service area? If it's not, great, then there's no first right of refusal from that provider. And if it is in a water service area, then the water provider would have to give and provide a non-objection letter, which basically says we don't object to a well going in our service area. It's something that those water suppliers are familiar with. So if you ask for one, it's kind of a run of the mill thing for them. It's not going to be something they never heard of. So if that issue is taken care of, then we kind of look at the size of the property. So properties for 35 acres or more are categorically eligible for these exempt well permits for domestic and livestock uses. So for properties greater than 35 acres, that would typically look like 3 single-family dwellings, some livestock use, and some irrigation. And for properties less than 35 acres, we would be looking at when the property was created or if it's exempted from county subdivision regulations. So parcels that were created prior to June 1st, 1972, some people might be familiar with that date, are eligible, and parcels that were created after that date would not be categorically eligible unless they are created in an exempt process from county subdivision regulations. Each county kind of handles this differently, but some counties have processes that allow for subdivision of land or creating new lots post 1972 that are exempted from subdivision regulations. And those properties would also be eligible for one of these exempt well permits. And then we also have a late registration process. So For wells that were constructed and used before that date, they can be late registered for exempt permits, but they can only be registered for the existing historical uses. So if a well was serving a single family home since 1965 or something, that well that kind of predates our registration system, we would be able to register that well, and so it has a permit and it's allowed to be used, but only for the historical uses. You couldn't come in and say, but now we want a garden. If it wasn't a historical use, then it doesn't fall into the late registration system. Like I said, we get this question a lot of, is my property eligible for an exempt well permit? And we can go through this system or go through this kind of this order and look at this, but we can't guarantee permits can be issued without an application. So an application and the filing fee and the documents that we require with an application basically gives us everything we need to formally and officially say, yes, this is eligible. Yes, it's not eligible. We can't guarantee or issue like a authoritative decision on about whether a property is eligible or not without an application. So that's something we encourage all the time. If someone has a question, is this eligible? Is this not eligible? I would just say, go ahead, get a completed application in, and in 4 to 6 weeks, you have a firm answer. And I think that's usually what people are looking for. So this slide, I'll go through it briefly. It's kind of basically what I just described as the process we would go through, but in a flow chart. So starting on the left, like I said, is the property in a water service area? And then at the top, if it's not in a water service area, we can move on. If it is in a water service area, but the water service provider will provide a non-objection letter, we can also move on. Or if it is in a water service provider and they won't provide a non-opposition letter, then it will not be eligible. And the water would then have to come from the water service provider. So then we move on to at the top, towards the middle, is it 35, is the property 35 or more acres? So if yes, then like I said, that property is pretty much categorically eligible for an exempt permit for those uses: 3 homes, acre of lawn and garden. And if the property is less than 35 acres, then it boils down to, was the property in its current form created prior to June 1972, or was it created in an exemption from subdivision regulations? And that kind of yields the final yes or no. A couple caveats. There's one exempt permit per property. So if you already have an exempt permit, you're not eligible for more and more and more. This is just a informational guide, so we can't guarantee this. Don't use this presentation to say you're guaranteed a permit. You must apply, and that the application and then receiving your permit is the ultimate kind of confirmation. We also do have some commercial exempt permits, and those are only for indoor drinking and sanitary restroom purposes. And then again, this is for outside of the Denver Basin and designated basins. So inside those basins, you might have some different options available to you. So some kind of typical guidelines for these exempt well permits, like I said, for parcels that are greater than 35 acres, you can have up to 3 single family dwellings, up to an acre of irrigation, lawn and garden, and then domestic animals, poultry, and livestock. For less than 35 acres, those exempt wells are generally limited to household use only. And they're only eligible, like I said, for pre-June 172 parcels or parcels that were created in subdivision exemptions. Like we've been saying, this outside Denver Basin or outside designated basin or inside designated basin. For inside the basin, you can have pretty much the same as the greater than 35 acre uses, and then some additional caveats apply to that. It gets pretty specific pretty quick about if it's non-tributary, not non-tributary, how much water is available, and then some additional caveats about the size and how the parcel is created. For late registration, we allow the historical, domestic, or commercial uses as long as they've been going on continuously since before May 8th, 72. For commercial exempt permits, they're limited to only indoor drinking, sanitary use. And then we have some livestock uses and monitoring holes and observation wells, which have kind of their own restrictions to them. So when might you, we've been talking about exempt permits, and then if you don't fall into one of those categories of creation or size, then that could be that you might need a non-exempt well permit for your property. So you might need a non-exempt permit if you're not eligible for an exempt permit because of those reasons. If you want to exceed the water uses allowed by the permit, so for example, a less than 35 acre property would be typically limited to single family home. If you wanted to exceed that and say have 2 homes, then that could be a reason why you would need a non-exempt well permit. If you want a second well on the property, or if you're seeking explicitly non-exempt uses such as crop irrigation, horse boarding, dog kennels, hot tub, swimming pool, etc., those would all be reasons why you would need a non-exempt well permit. So for these non-exempt well permits, if the property is not eligible for an exempt well permit or seeking uses that are not allowed by exempt permits, like I said, it's likely that you would need a non-exempt permit, and then it's also likely that that non-exempt permit would need an augmentation plan. Since the vast majority of the state is over appropriated, if you're going to have a non-exempt well permit, which is then administered under the prior appropriation system, then the water use from that non-exempt permit is going to need to be replaced so we can protect senior water rights, and then therefore that's going to require an augmentation plan. So fortunately, there are some existing umbrella augmentation plans, which are augmentation plans that are already existing, that are approved by the water court. They have an amount of replacement water already secured. And so people can join these existing plans. You basically register, say what your water uses are going to be, pay for the amount of water that is associated with that, and it's kind of already covered. Not every area has an umbrella augmentation plan. So you could go to the water court and create an augmentation plan. We would recommend hiring a water rights attorney to help in applying for that. It can be kind of a complex process.
Do we want to take a quick break and meet back here at, say, 10:30? Does that work for everyone? Awesome. I will be here to answer any questions in the chat during the break if you have any, but we will see everybody back at 10:30. We actually got some questions in the chat that were kind of interesting. So for those of you that are still here, one of them was asking if ditch rights are owned by the ditch company or the shareholders. Now, I'm not part of a ditch company, so obviously I can't speak for all ditches and all ditch companies, but my understanding was that the shareholders um, own the right to the water that they have shares for. And we have an example of a share certificate later in the presentation. We also had a question, if somebody has a 35-acre property that's been subdivided, can the existing well that's permitted for 3 homes be used for the lots? The answer is probably not. When you have a well and you subdivide, most of the time the well has to be re-permitted as a non-exempt well and augmented in most cases. There's one exception where you could continue to use the well depending on how the well was permitted, but the well cannot be shared even if you can keep its current permit. If you have a question like that, like we have a well permit, the land has been divided or subdivided, we don't know if the well permit is valid or if we need to re-permit, I would send us an Ask DWR with the permit number and the property so that we can take a look. Just because every permit is a little different, the rules are different depending on what area you're in, so it's hard to give a blanket answer as to whether you could continue to use the well or if you have to re-permit it. Then we have a question about if a retention pond or when does a retention pond as opposed to a detention pond require a water right? I'm not sure if we cover this in the presentation, but we have 2 minutes. So detention ponds, if it's a stormwater detention pond and it qualifies under the statutory definition of a stormwater detention facility, you don't need a water right or an augmentation plan for that stormwater detention facility so long as it qualifies. There's information on our website for what qualifies, and those are essentially exempt from the priority system. So say you have a detention pond that only stores water for a brief period of time and releases all of that water within 72 hours, and it's really just to prevent flooding when there's like a storm. That doesn't need a water right or a augmentation plan. Now, if you have a retention pond, I guess it depends on what you mean by retention pond, but a lot of times people just mean a holding pond. So you're basically diverting surface flows or collecting them in a pond. That's storage and needs to be done in priority. So if there's free river conditions, you can do that without a water right, so long as you coordinate with the water commissioner. In a lot of areas, there are not free river conditions, so you would need a water right or an augmentation plan to store water in a retention pond. Okay.
That's a great question. I hadn't considered that before. Like, what happens to, the water in the stormwater systems?
Yeah. Okay, there's I guess, Aaron, maybe I could ask you, there's 2 more questions. Should we just answer those real quick and then we can go back to the presentation?
I think so. That's fine.
Okay, sure. Okay, there's another question. Once an application for a well is submitted, that people can dispute all applications and hold the process for up to 2 years. Is this true? No, there's not. I would say generally no. Like, people are not submitting objections and holding up the process if they have no claim for injury or have no interest in the application. Like, random people can't just say, I'm going to hold up your application. There is a process where, for example, 600-foot spacing, if you have a well within 600 feet, that is a process where you could file an objection potentially, and it could go to a hearing, but that doesn't apply to all wells. And then the second question is, how does DWR do enforcement? How do they monitor non-exempt wells if they are complying? So for non-exempt wells, a lot of those have to be metered and they have to submit their meter readings and accounting to show that they're using the amount of water that they're supposed to. It's a very simplified answer, but that's kind of the short answer. Okay. Erin, could you share your screen again and then I'll get started? Okay, so I want to go over how to use our well permit search tool. And so that link is on the bottom of that slide there, Erin. Yep. So that's the link to our well permit search tool. If you're a realtor and you've been selling property with wells, you probably are familiar with this tool. So I want to go over how to use it, but also some tips to maybe make your searches more effective. So usually what I would do if I'm in this tool is I would click in that more options field. It's the very last one, and it's this drop down box. And you can search by address, by PLSS, which is section, township, and range. Erin, could you go to the next slide here? Okay, yep, perfect. So those red arrows are just next to the most common search fields that we tend to use. A lot of people will use address. That's a great place to start. What I will say about searching by address is that we issue permits for a specific point location or for a specific tract of land. We don't issue permits to a specific address. That's because of how statute is, but also because a lot of properties don't have addresses or addresses can change. So if you're searching by address and you're getting a lot of permits coming up and you know there's only one well on the property, that's probably because the search is pulling up all well permits within a certain search radius of the address that you put in. So you could always narrow or widen your search radius if nothing's coming up by address. You can also search by applicant name. So if I'm searching for permits in the name of John Smith, then I would type in Smith, comma, John, for example. And if that's not working, again, I would maybe make your search a little wider and look up Smith, and you can always narrow it down by county. Like, because if you search for the last name Smith in the entire state of Colorado, you're going to get a million search results, right? But you can narrow that down and search just for well permits in the name of Smith in Weld County, for example. And then if you know the permit number, that's probably the fastest. Go ahead and type in that permit number. It might ask you for a suffix or replacement suffix. So that's just something also to be aware of. So you might see permit number 123 and permit number 123-A. The -A means that that a replacement permit was issued. You might see 123 with no suffix and 123-F. Those are different permits. The -F is for a non-exempt permit. If it has no suffix, it's for an exempt permit. So if you see two permits with the same number and one has a -F and one doesn't, those are different permits and not related. So just another thing to keep in mind, because sometimes people call us and they're a little confused about that. And then PLSS is another way to search. So if you know the quarter, section, township, and range, that's another good way to search. And lastly, subdivision is a really great way to search because sometimes people will type in an address and they'll get nothing or they'll get 10 results. And they're like, I don't know which one is for this for the well that I'm actually looking at. If you know that it's lot 5 of Highview Estate subdivision in Douglas County or whatever, that's going to get you a much more precise result than address because again, address searches by search radius. It'll search for everything. It'll use that address. It'll probably spot it from Google and search for everything within like 500 feet, which is why you might get good or bad results. Searching by lot, block, and subdivision name and filing number is going to get you much more exact results if the well is in a subdivision. So let's go to the next page. So once you use the search tool and you click on a permit, it's going to take you to the well permit overview page. This is a summary of the permit. It is not the actual permit itself. It's just showing you generally where the well is, information about uses, that kind of thing. You want to click on image documents to actually get to the well permit file, and that will have information like the permit itself, the application, any maps, any construction or pump installation information that we have. So if you go to the next slide, Erin, here we have, once you click on image documents, this is what the page will look like. And if you want to look at information that's relevant to the permit file, you want to make sure that you're clicking on that template that says well permit information, that blue arrow is pointing to. That will show you all the documents that we have on file for that permit file. Sometimes when you click on this page, a well might be decreed. So if you click on the water court template on the left there, it'll show you court documents that are related to this well, but it won't show you the well permit information until you change the template to well permit information. If you are not able to find a permit, please call us or email us. I will say it's unfortunately common for people to file change of owner name forms or other types of forms for the wrong permit because they use this search. They grab the first permit that comes up. Maybe I'm not sure exactly what the process is, but they grab a permit number that looks right, and then they file the form for it without double checking that that's the correct permit for the property. So if you're not sure if you're looking at the right permit, I would give us a call or email us. Okay, we had a question earlier. We are getting to this. What if a well doesn't have a permit? I want to say first, if you can't find a permit for a well, I wouldn't automatically assume that it doesn't have a permit. I would call us first to see if we can find a permit. We're really good at finding permits. So if you think this well might have a permit and you just can't find it, please call us or give us submit an Ask DWR. We will try to track down the well permit or help you determine if there is not a permit. Now, let's say we've determined that the well definitely does not have a permit. We go over the 3 scenarios that could happen depending on when the well was constructed and used. So the first scenario, which is very, very common, is if the well was constructed and used prior to May 8th, 1972, and the well doesn't have a permit, that's okay. The first question that people have is, I've got this well from 1950. I use it for the house. That was also, it's from the 50s. Is that a problem? My well doesn't have a permit. On its face, no, because prior to May 8th, 1972, you didn't need permits for certain domestic uses. But if you are selling the property, you should be aware that the buyer is required by law to late register the well within 60 days of closing. Of course, the seller can register the well beforehand. There's nothing preventing the seller or the owner from registering the well before that. But if it hasn't been registered and you are the buyer, make sure to get that application in within 60 days of closing to get that well registered. Now, let's say that the well was constructed and used after May 8th, 1972, and there is no permit or there is not a valid permit for this well that we could possibly reinstate. Technically, this well would have been constructed without a valid permit, which isn't permitted. But we could try to get this well permitted. We would need a post-construction well inspection report to make sure that the well was constructed properly. And we would also need Form GWS 44 if it's a domestic or livestock well. You'd have to submit both of those to our office, and we would review that and ideally be able to issue a permit. But just know that if the well was constructed after May 8th, 1972, you have that added inspection that you need to do. Now, there's also cases where the well was constructed and there was a permit, but it expired. Well permits will expire if the construction report is not submitted showing that the well was constructed before the permit expired. So there's a lot of cases where people get a well permit. It has 2 years until it expires, and then they construct the well, before it expires, and then for whatever reason, they never turn in the well construction report. So in our database, we expire it because we have no idea it was constructed, but in real life, the well was constructed. So there are cases like that. We would point you to guideline 2017-1 that goes over all the different scenarios that could happen. But there are some cases where we might be able to get that well construction report or post-construction well inspection report. So either the original report or an inspection, and see if we can reinstate that permit. I want to go a little bit more into registering these pre-May 8th, 1972 wells. Aaron talked about it briefly, but I do want to reiterate that when you go through this late registration process, and that's using Form GWS-12 to register these wells, they can only be registered for the historical uses that occurred prior to May 8th, 1972, and have continued since that time without a gap in use for more than 10 years. So for example, let's say the house was constructed in 1950. We don't know when the well was constructed, but it's probably safe to assume the well was constructed in 1950 as well to serve the house. And that historically, since 1950, they've used it for the house and an acre of lawn. And then let's say in 1980, the house connected to Denver Water, and now they have a tap, but they've continued to use their well for their 1 acre of lawn. So in that case, when they come in to register their well, we'll ask them, show that the well was basically, when was the well constructed? And they'll say 1950. Okay, it's before May 8th, 1972. But in terms of uses, they can only claim that 1 acre of lawn because that's a pre-72 use that has continued since that time without a gap in use of 10 or more years. The use in the house, while they were originally using it in the house, they haven't used the well for use in the house since 1980. So they cannot register that use because it's considered abandoned. So that's just kind of an example of what might happen if the use has changed over time. You can also late register wells for commercial use, and that commercial use is limited to indoor drinking and sanitary purposes only. So sinks and bathrooms for employees inside of a business. It can't be used for outside landscaping or irrigation. Okay, now we'll get into kind of the FAQ question, common issues that we see when people are selling and purchasing property. So the first thing is, if you are trying to determine whether a property might be eligible for an exempt permit, you want to look at how the lot or parcel was created and when it was created. So I would go back to that flow chart that Aaron was presenting on earlier to determine if you can apply for an exempt permit, and if so, what the allowed uses would be. And then you also want to look at what is the current water supply, or what is the intended water supply. If the current water supply is an individual well, you want to make sure that if the well has a permit, or that it can be late registered. If it has a permit, you want to make sure that that permit is actually valid, or that it's being used for what the well is permitted for. There are times where people say, yeah, I've got a well and I use it for the house and my horses. But then you go and look at the permit and it's actually only permitted for household use and not for horses. So you want to verify that the permit can be used for what you intend to use it for. If there's no permit, again, going back to that flow chart to determine if the property is eligible for an exempt permit. If not, then determining whether you can get a non-exempt permit in an OG plan. If the well is being shared, you want to make sure that the well can legally be shared. So again, we have seen a lot of situations where 2 properties are sharing 1 well, but when you actually go to look at the well permit only allows use in 1 home. So again, just because the well's been shared for the last 20 years doesn't mean that they've been legally sharing it. Always double check the permit. We would also highly recommend that well sharing agreements be recorded with the county to just document how the well is going to be used and how maintenance and costs are going to be shared. We do not enforce those agreements, but we do encourage them. If the property is going to be served by a central supply, you want to check if taps are available. I will also point out that DWR does not issue will serve letters or taps. We are not a water supplier. You would have to check with the water district. Another common question we get is whether a test or an inspection is required when a property is being sold. For private wells, there's no state requirement that wells be tested or inspected. And I kind of like to think of it as if you have a well on your property, you're your own private water supplier, right? So it's really your responsibility to make sure that the well produces and is of a quality that works for what your needs are. Now, that's not to discourage you from having the well tested or inspected. You certainly can have that tested or inspected beforehand. And especially maybe for older wells, because sometimes people call us and ask, well, we've got this well, it was drilled in 1990, and the last information that you guys have is the pump installation report showing 2 gallons per minute. Is that still what it's producing? Our office couldn't tell you because the only information we have is from 1990. So in that case, you might want to have it tested, or if the owners have tested it recently, get a copy of that. We did get a question from Stacy, what's a private well versus a well permit? I guess I just use the term private well when I'm talking about a well that's serving the property and you're not actually getting water from a water supplier. So a, a, I guess something that's not a private well would maybe be a water district that has a bunch of wells that they use for their water supply. That I wouldn't use the term private well for that. That's not a really great term. I was just trying to distinguish the difference between getting service from a utility versus having a well that just serves your property or a few properties. And then septic and leach field or central system for wastewater treatment. I just want to point out that our office does not permit septic systems. That's typically something that's handled by the county health department. So I already talked about this a little bit, but I'll just say it again. This is kind of a handy list. If you have an existing well and you have a permit and you're not sure if the permit is valid, here's a couple quick questions to get you started. So the first one is making sure the permit is not expired or canceled. If the permit's expired, then you might want to look at why is it expired? Did we just not get the construction report in and maybe we can get it reinstated under guideline 2017-1, or maybe it was canceled because it was replaced with another permit. That happens sometimes. Do the existing uses match the permitted and decreed uses? We added decreed uses in there too, just because some wells have a permit and a water right. So you just want to make sure that all of those uses match. And then has the property been subdivided or divided since the permit was issued? I talked about this a little bit on the break, but a lot of exempt permits I would say most exempt permits are issued for a specific tract of land. So a well permit issued for 40 acres encumbers those 40 acres. If you subdivide it or divide it into 2 lots, you might have a problem because now you have one permit that encumbers all 40 acres, and that could create a problem where the other lot is not able to get a permit because it's encumbered. Another issue might be, and we don't have a slide on this, but I do want to mention, if you subdivide, statute requires that our office consider the cumulative effect of all wells in determining whether or not there's going to be injury. What that means is that in over-appropriated areas, if you subdivide all wells, for the most part, including existing wells, have to be augmented. So that's something to watch out for. If you see an exempt well permit, it's issued for a certain area, and you notice that the property is actually smaller or has been reconfigured because it was divided or subdivided, in many cases that well is not in compliance with the permit anymore and likely needs to be re-permitted and very likely needs to be augmented. So that's also something to pay attention to. And again, if you're not sure, you can always contact us and say, hey, this well was permitted this way. I noticed the property is actually this size. I'm a little worried about if I buy this, that the permit's not valid. That's always something you can email us and ask about. Also, change of owner name forms are filed with our office to update the contact information for a well. This is something that the buyer needs to do, or if they're going through a title company, the title company will file the change of owner name for the buyer. I will say for this that the change of owner name form does not convey any real property. It is only for updating contact information in our database for these permits. So just keep that in mind. Another thing I would mention is that you need to have the permit number and you need to have a valid permit number. If you're selling or buying a property and you give the title company an expired permit number or a canceled permit number, they will not be able to file they won't be able to file this form for you. And then also you don't have a valid permit for your well. And then just a quick note, if there's other water rights on the property, you want to be aware of what the decree says. There will be limits on the point of diversion, the quantity of water you can divert, and the uses. So sometimes people get excited when they're going to buy a property and they're like, oh, this comes with water rights. I can do whatever I want with it. No, there are limits. You have to be aware of what those limits are. And as Aaron mentioned earlier, water rights are treated as real property separate from the land. Just because you buy the surface land doesn't mean that the water rights automatically come with it. They're kind of like mineral rights in that you can purchase the land without getting the mineral rights. And then something else that we see is that a lot of times properties will have a pond on it, and people kind of assume just because this pond has been here for forever, surely it's in compliance. Not necessarily. If this pond is man-made and it's not a stormwater detention structure like I talked about earlier, the pond, if it exposes groundwater, it has to have a permit, and you have to divert in priority. To sum this up, I would say that a lot of ponds are not actually in compliance, and you might have to get an augmentation plan in order to actually operate this pond, or in some really bad, actually, I'll tell this story. It's a terrible story, but I remember that a couple years ago, there was this client who purchased this. It was a multi-million-dollar property because it was this lakefront property. They paid a lot of money for it because it was a lakefront property. They closed, come to find out that this lake was man-made and not in compliance. And we told them, you need an aug plan, you need to pay for augmentation water, or go to water court and hire an attorney, or you have to backfill it. And so that's just kind of a cautionary tale. Always make sure that any ponds on the property are in compliance. You can call us to check, because you don't want to close on a property and find out that you have to spend, $100,000 to backfill the pond that you just spent millions of dollars on. Okay, next slide. Just to revisit this, is the permit valid question? We already talked about the permit possibly being expired. Another common issue that we see is that the well is actually more than 200 feet from where it is permitted or decreed to be. That is certainly something that you want to fix. If it's more than 200 feet from the permitted location, but still on the property that it's supposed to be on, that's just a form you can file. If the well is more than 200 feet from where it's decreed, so from where the water right says it has to be, you have to file an application with the water court to change that. So our office, we do well permitting. We cannot change a water right. That's something you have to do through the water court. And then I already talked about making sure that the parcel for which the well permit was issued matches the current configuration of the parcel. Otherwise, you might need an augmentation plan. And then this photo kind of just shows you like the permit history, showing you when the permit was issued. A lot of times it'll say when the permit expired. So you can check the well permit overview page to see if that permit is valid. But again, if you're not sure, you can contact us. In terms of determining what the allowed use is on a permit, we just put two different examples. One is an older permit on the left, and the other one's a newer permit in the middle here. So on these older permits, the allowed uses will be under the conditions of approval on the right side. So I circled those in red. The left side is the application, just so you're aware. And then in the middle is a newer application. I've circled where the allowed uses are often spelled out. So where the uses are on the permit kind of depend on how old the permit is. Again, if you're not sure, you can contact us, and then I will hand it off to Aaron.
Sweet, thank you. So getting more into those allowed uses, we get a question of, we get used questions all the time. Can I use my exempt well? So exempt well would be out of the priority system, and they typically don't have suffixes like F or FP. So can I use an exempt well for crop irrigation? No. Can I use an exempt well for horse boarding? No. Can I use an exempt well for ADUs or secondary dwelling units? Maybe. So that's one we'll get into. Can I use an exempt well for hot tubs? No. So the allowed uses of exempt well permits are determined pretty strictly by statute, and that statute specifies the allowed uses. So ordinary household uses in a specific number of residences, irrigation of home, lawn and garden, as opposed to commercial lawn and garden, watering of domestic animals, and the watering of poultry or livestock on a farm or ranch. So most of those would be exempt uses for 35-acre or greater properties. That's where you get into multiple residences, where you get to have a lawn and garden, domestic animals. And then for less than 35 acres, it's typically for ordinary household uses in a single residence. So exempt uses can include domestic uses, and domestic can have different definitions based on kind of when a permit was issued, or like I said, the size of a property. So the permit file might have some more details, and if you have questions, you can always ask with the Ask DWR portal or the info desk. So while domestic wells, and for properties greater than 35 acres, can have irrigation, that irrigation is still kind of limited. So domestic wells on less than 35 acres, like I said, typically only inside use at a single family home. And then domestic wells for greater than 35 acres allow for irrigation of 1 acre, but for residential use. So here we have an example of a listing for a 75-acre cabin with a barn. And on the listing, the seller advertises that you can grow marijuana legally for your own use or for distribution. And so distribution would be not a residential use, it would be a commercial use. So irrigation from an exempt well for this property would not be eligible. So I would say don't always trust what you see, and if you have questions, you can definitely ask us. So for hot tubs, pools, and ponds, like I said, the statute pretty explicitly spells out what the allowed uses are, and these are not don't fall under that statute. So they're not allowed by exempt or small capacity well permits. Man-made ponds must be augmented and permitted because they're not exempt uses. And then augmentation plans are the only way to add non-exempt uses or to have a man-made pond. So sometimes people call and they say, oh, I have a less than 35 acre exempt permit for a single family home, but I want to have a hot tub. How can I use that? And so that the only way to get that approved through DWR would be to be joining an augmentation plan. So these augmentation plans, some wells in newer subdivision are covered by augmentation plans. That's because of that 1972 date, that June 1st, 1972 date, and that if subdivisions were created after that date, like we said, properties created after that date are not eligible for exempt well permits, and so they would need non-exempt permits, and those non-exempt permits would need augmentation plan. So some subdivisions have their own specific augmentation plans that are like created when the subdivision is created. And so all of the lots fall under that augmentation plan. And if that's not the case, then new non-exempt wells in those subdivisions would need to either join an existing umbrella augmentation plan or create their own augmentation plan, which would, again, we would recommend hiring a water rights attorney for that because that process can be kind of complex. So the one maybe we had on our can I use my exempt permit for something was on these ADUs. So we get a lot of questions about ADUs. The additional dwelling or the ADU to be used under the exempt permit must qualify as an extension of the main single family dwelling as described in this guideline we have 2016-1. It's not too long, so if you have questions about it, I would definitely recommend reading it or skimming through it. And so for a property or an ADU to count as an extension of the main single family dwelling, it has to be occupied by guests or family or caretaker and not rented or leased for profit. It would have to be for residential use only, so you couldn't run like a commercial business out of an ADU. And then if the ADU has an independent entry and is separated from the primary living space, the ADU can't then contain a full kitchen facility. So if we have an ADU with a full kitchen facility, which I think we define as having a fridge of a certain square footage and like an oven, then that would count as a separate, as not an extension of the main dwelling, but a separate dwelling. So if your ADU is separated and it has it contains full kitchen facilities or it's rented or leased, then it would only be allowed under an exempt well permit if the permit allows for additional dwellings. So like we said, greater exempt permits on properties greater than 35 acres can serve up to 3 single family dwellings. So if you had a ADU that doesn't count as an extension, you could still have it under your exempt permit as long as there were not already 3 single family dwellings being served by an exempt well. Or like I said, as always, you can look into augmentation to add non-exempt uses to your permit. So here's the flow chart for that property or for that process. Like I said, the question we get all the time: Can I have an ADU on my property? Basically, so we would ask: Does the ADU result in exceeding the number of residences? So no. Like if you had a greater than 35 acre property, that would be eligible to serve up to 3 single family homes. If you only have 1 or 2, then adding 1 more would not be exceeding that 3 number. So then you can be permitted for an ADU. If you only have 1 residence, or if you have a single family, a permit that can serve a single family, 1 single family home, so less than 35 acre property, then adding an additional second dwelling would exceed that 1 number, and then you would need to determine if the ADU qualifies as an auxiliary living space or an extension of the main home. And so that's where that 26.1 guideline comes in. So like I said, if it's and this can vary county to county, and we have our own guideline on it as well. And it basically comes down to is the ADU separate, and does it have its separate? And separate could mean like having a door between the ADU and the rest of the home, even if they're not physically separated, if they're under the same roof. Or and then if the ADU has a full kitchen facility in it, if the ADU is being rented out to someone who's not in the family or a caretaker, all those questions kind of go into: is this an auxiliary living space or is this an extension of the main dwelling? And then additionally, so if you're adding an ADU, it still has to be operating in accordance with your permit. So like we talked about, no commercial use, and there could be some other limits on it as well, like irrigation or things like that. If you're considering purchasing a horse property, you should know that county zoning is independent of state statutes. The property still might only qualify for household use, which would be an inside use only well, even if a county has its zoned ag. It's kind of a separate system. We do consider horse boarding a commercial use, and so that would not be allowed under exempt permits.
We've just got a few more topics till we have time for questions. So I just want to cover a few water rights and water administration topics that we haven't covered yet. The first one is ditches and reservoirs. So as Aaron explained earlier, we are a priority system. We do not have a riparian system. So if you purchase property that has a ditch running through it or a reservoir, if you don't own the water right for that water, you cannot take water from that ditch because it's not yours to take. So that is something that we hear sometimes is somebody buys a property and a little creek runs through it or a ditch runs through it and they think, oh, I can just throw a pump in. No, you need to have a right to that water before you can use that water. Another item is that ditches and reservoirs have legal easements. So the owners of those structures or of those water rights have a right to access those for use and for maintenance. So that's something to also be aware of. Sometimes people think, well, there's this ditch running through my property, but it's on my property. I can prevent people from coming onto the property to access the ditch. That's not correct. If someone has a right to that water and owns that ditch, or the water commissioner needs to access that ditch, they have a right to do that. Another item is that DWR does not resolve ditch easement or ownership issues. We administer water, but we do not get into civil matters essentially. So if there's a dispute over who owns this, or you don't have an easement for this, that's a civil matter that needs to be worked out between the two parties or in civil court, worst case scenario. The other topic I wanted to talk about is precipitation collection. So there's two ways that you can collect precipitation from the roof of a building. The first way is if you have a residence that is for single family or 4 or fewer units, you can collect precipitation from that rooftop using up to 2 rain barrels with a combined storage capacity of 110 gallons. So like 2 55-gallon rain barrels, for example, and you can use that water outside. And you don't need a permit for that. You just need to qualify in order to do this. And this is just from residences. So you can't collect rain from the rooftop of like a commercial building or something like that. The other way that you can collect precipitation is with a permit. And this is only for properties that would qualify or currently have an exempt well permit. You would use Form GWS 78. There would be a fee if you are not also applying for an exempt permit, and you can only use the water for the allowed exempt uses. So if you have 35 or more acres and you have outside domestic uses, you could apply for precipitation collection permit and use that for your lawn and garden. But if you have a less than 35 acres and you have a household use only permit, then if you got a precipitation collection permit, you could only use the rainwater inside the house. So these are the two options that you can collect rooftop precipitation without needing a water right or an augmentation plan. I already talked about this, but it's just nice to have it on its own slide. Just a reminder that the contact information for well permits can be updated with our change of owner name form, and that's submitted online. There's no fee to file this. If you are purchasing a property, make sure that you transfer the permit over to your name. It does have to be a valid permit in order to do that. The title company will do that on your behalf, so long as you provide them the valid permit number upon closing. And then just a reminder, this form does not convey real property. If you are purchasing a property that has a well permit and you update the change of owner name form, but let's say the well also has a groundwater right, you need to also make sure that that water right is transferred to you also if you want to own the rights, own that water right. This form does not transfer water rights. You would need a deed to do that. So my next slide talks a little bit more about ownership of water rights. A lot of times people call us or realtors call us and say, we're selling this property, but we don't know if there are water rights that go with this property. I usually tell people, if they say, I have no idea if I own water rights, if you didn't purchase water rights, you don't have a deed showing that you were transferred water rights, you don't recall going to water court to get water rights, like none of those things, then you probably don't have water rights. Again, that goes back to the priority system. There's kind of this misconception that when you purchase property, water rights come with it. Again, that is not the case. Water rights are treated as separate real property from the land. So for groundwater rights, again, a lot of well permits don't have water rights. Some wells do have water rights, and those should be transferred via deed. Surface water rights could be transferred via deed, but sometimes if it's a ditch that has shares and is operated by a ditch company, you would be issued a certificate showing that you own a certain number of shares from that ditch company. We would recommend that you talk to the ditch company regarding ownership questions for that. And then on the next slide, we have, oh, I forgot to mention, sorry, don't, I forgot to mention that when water rights are deeded, those deeds should be recorded with the county. So when people ask us, oh, do I own water rights? Does this property come with water rights? I just want to remind everyone that we administer water rights, but we don't track water rights ownership. There's unfortunately not like a statewide database that tracks water rights ownership. So a good place to start would be talking to the seller or the owner. If they don't know or they can't find their paperwork, you could check with the county clerk and recorder to see if there were deeds recorded transferring water rights. If they think that they own shares to a ditch company, again, talk to the ditch company. Our office can sometimes get you started. We can look and see what wells are on the property, if there is a decree for other structures like a spring or a pond on the property. But again, we can't tell you who owns the water right because we don't record those deeds and we cannot provide an opinion on ownership either. If you need to do research on water rights, we would recommend that you talk to a water rights attorney and also look at the county records. On this slide, we have two examples of what water rights ownership documents could look like. On the left is a share certificate. So of course, they don't all look like that, but they kind of look like that to some extent. And then on the right is a deed transferring water rights in the Denver Basin. Actually, this is a designated basins. This is transferring designated basin groundwater in the Denver Basin. And then just on the bottom is that reminder that we don't provide opinions on ownership of water rights. And we also do not prepare transfer deeds. So that's another question that we get is, we're going to close and can DWR tell us how to write the deed? That's really something that an attorney should be doing. I don't know if I have any title companies online right now, but I've also been told that title companies, they'll prepare the property deed, but for the most part, they don't do title insurance, title research on water rights, and they don't typically prepare water rights deeds. For the most part. So that's also something that if your title company doesn't provide that service, and we obviously don't provide that service, that's something that you would want to talk to a water rights attorney about. And now we have all of our resources on this slide. So there's our website. There's the link to our Ask DWR request. So if you have a somewhat complicated question, you want to send us, there's some maps or other attachments you want to send us, and Ask DWR is a really great way to ask that question. We also have our records section, and that's a good place if you're just looking for a permit or you need a copy of something from a permit file. Our info desk is also a great number to call if you have a groundwater specific question. You're trying to figure out what a permit can be used for, or trying to figure out what the permitting options are for a particular property. And we do have walk-ins, but in the Denver office, they're by appointment only. And I think with that, I want to open it up for questions, and we can go till 11:30. If anyone wants to drop a question in the chat or unmute themselves. I did want to say we had a good question in the chat about how how long until well permits expire. Currently, exempt permits, once they're issued, they are valid for 2 years. So you have 2 years to construct the well. They can be extended, but you have to submit the extension request before the permit expires. Non-exempt permits are currently valid for 1 year. So you have 1 year to construct the well and install the pump before the permit expires. You can extend that for 1 year for a fee. There was a legislative change, so I believe that will be changing in September, though. So non-exempt permits will soon be similar to exempt permits in that they're valid for 2 years, but there won't be an extension option. Is that right, Aaron?
Yeah, I think so.
Okay.
And then I just wanted to add to that too, that if you have a well permit or your property has a well permit that expires, you can reapply for that well permit. It's something that happens all the time, and there's no like real penalty for it besides paying another filing fee. And so that happens occasionally. If someone's interested in selling their property, they might apply for a well permit so that they can show to the seller that their property is eligible for a well permit, even if they don't plan to construct in the next couple of years. So that's what I was kind of saying earlier. I mean, besides the $100 filing fee, applying for a permit is kind of a good idea, just to have that definitive answer on whether your property is eligible or not. And then if the permit, even if you don't plan on constructing, you can still get the permit. If it expires, you can just apply for another one when you're ready to construct, and that happens all
Yeah,
the time.
that's a great point, Aaron. Another common question we get is if a permit has expired and the well was never constructed, sometimes people ask, can we resurrect this permit? Once a permit has expired and there's no way to reinstate it because the well was never constructed, you just have to apply for a new permit. We can't reinstate certain permits. And then we have a question online. Does the property owner or the driller apply for the permit? That's a great question. So you have to be the property owner or be under contract if you're outside of Denver Basin in order to apply for the permit. That's the person's whose name needs to be on the application. But drillers can be a great resource to help you fill out the application. A lot of drillers will help people fill out the form and get it submitted, since a lot of people are unfamiliar with it. So certainly the property owner name or whoever's under contract needs to be the applicant. But in terms of getting help, the driller is a great resource. I have a question from Stacy, if it's possible to have a class to provide more in-depth information on ditches and reservoirs in regards to irrigation. We unfortunately don't have a class for that right now. We just have a this well permitting class, and then we have a water rights class. I would recommend that, assuming we won't have that anytime soon, to talk to your division office with your specific questions. Shara, thank you for all of your help in the chat. Talking to your water commissioner. I think that while it might be helpful to have a class more on water rights, water administration, rather than well permitting, it is sometimes tough to answer those types of questions because they can vary from division to division. Each person's water right can look a little different. But yeah, contact your water commissioner, your division office. And I will also say, if you are a licensed contractor or a realtor seeking continuing education credit, I emailed everyone yesterday. If you can just email me your name and your certificate number, I will email you back the signed continuing education certificate. Last call for questions.
Can you hear me?
Yeah.
Oh, great. Thank you both. This has been really helpful and great to hear. So I have a property, it's 35 acres. I was talking to you before in the chat, and the owner had divided it into 6 parcels. There's one well on the property, and that description says that it can be used for 3 single-family dwellings, irrigation of not more than 1 acre, and garden, lawn, and watering of domestic animals. So when I sell this property, is it possible to put 6 homes on this property since it's been divided into 6 parcels? And then
Where is the property located?
we're in Eagle County.
And then when was it subdivided?
So I think it was subdivided in 1988. The well was issued in 1998,
Mhm.
but I might need to confirm when the subdivision happened.
Okay, yeah, that would be really critical to know. So essentially, the only time, because it sounds like what you're describing is an exempt permit, the only time you could keep that exempt permit and use it on a single lot, it cannot be shared. The only time you could keep that permit is if the well permit was issued, the well was constructed, and then after it was constructed, the land was subdivided. And all of the land that the well encumbers has to have been subdivided. So say and that's likely the case, but say the
Okay.
well permit was issued for 35 acres, then it was all 35 acres was subdivided into 6 lots. It sounds like maybe in that case they could continue to use that well permit for 1 lot only. The other 5 lots, they have to be augmented in order to get a well permit.
Yeah,
And
that would be my understanding, is that the initial well permit was issued based on the lot being more than 35 acres. And so now that the new lots are there and they're less than 35 acres, or that 35 acre chunk was already used or encumbered, like Winley was talking about, encumbered to justify the issuance of that full domestic, we would call our three home lot. So that land has kind of already been accounted for. So new wells on that, I would imagine, would
Have to be
yeah,
augmented.
unless, and the other caveat is, unless the subdivision process was done in an exemption from county subdivision rules, which you would want to ask Eagle County, like if it was how it was subdivided, like, you know.
Right, right. That's a great point. So yeah, I would say generally what we said is my guess, but if you wanted to know for sure, we would need to know the permit number and also when the property was subdivided. Because you said you were in Eagle County.
correct.
There's some areas where if it was subdivided before the area went over appropriated, they might be able to get exempt permits, but that's why we'd have to know exactly where it is and the permit number.
And
Okay.
I believe have an application to give you like the most definitive answer. So
Right,
if you
yeah.
wanted to like apply for a new well permit on one of those new lots, then we would have, kind of all the information to be able to say yes or no, or like, yes, you can have a permit, but you need an augmentation plan, or yes, you can have an exempt permit on something like that. So
Yeah, Amy, if you want to email me directly, you can, because I actually work in this area.
Great. That'd be very helpful. Thank you.
Awesome. We've got 5 minutes left. I think since this is Q&A, if anybody needs to hop off, feel free. But we have 4 or 5 minutes more for any last questions if you want to stay on. All right, I don't see any other questions, so I want to thank everyone for their time. Again, email me if you need that continuing education credit certificate, and I will also send out the recording. Thank you, everyone.
Thanks, y'all.
Thank you.